Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have another document in the Stephanie Jones versus Justin Baldoni and Jennifer Abel side of all these lawsuits. And this is Stephanie Jones' attempt to get the judge to prohibit the Wayfair parties from getting access to certain documents they're seeking from their security firm. Now, before we get into this, remember the security firm played a role because Jennifer Abel alleges that she was basically forced to give up access to her, phone documents, whatever. She was forced to sit in that room, and she was, at one point she was saying that she was falsely imprisoned, though I think in the amended counterclaims they did drop that one. But they don't want Justin Baldoni to access their communications with the security firm. I wonder why. But let's hear what they have to say about it in just a minute here. I will say that it is raining outside, and I'm upstairs, so it might get a little loud. Hopefully it won't, though. Give me 1 second. I have the document pulled up here. There's a few letters to go through. It is 30 pages, but most of it is like, stuff to scroll over. It's like contact info and stuff like that. Jones is hiding a lot. Man, she sounds pretty wild. So, all right, give me 1 second. And, Edgeworth Security is obviously not a party to this lawsuit. So this is a third party. They're seeking documents from this third party. And Stephanie Jones would like the judge to stop them from obtaining these documents from this third party. So there we go. Okay. Is it even possible to block discovery? Well, like when they were trying to subpoena phone records, you remember Brian Friedman and Wayfair's attorneys asked the judge to temporarily, stop them from enforcing the subpoena to get the phone records because they were asking for a very broad scope of information. And so he did, in fact, block that temporarily. And then they had to get a new subpoena asking for more, a narrower scope of information. So demanding blocking discovery is very telling, IMO. I don't know how common this is, man. I mean, this is my first time really following anything this closely. So other than the fake pregnancy case, which is very, very different. Okay. All right, let me zoom in a little bit so you can read on that. Actually, you probably can see, right? Yeah, there we go. It's Saturday here in, wait, what's ZA? I don't know where that is, but happy Saturday. Okay. Dear Judge Liman, pursuant to Federal Rules of Civil Procedure 26 and 45, Local Civil Rule 7.1d, and Paragraph 1c of this court's individual practices in civil cases, we write on behalf of our clients, Jonesworks LLC and Stephanie Jones, to respectfully request that the court enter a protective order prohibiting the Wayfair parties from enforcing a subpoena served on Edgeworth Security Services LLC that improperly seeks to obtain Jonesworks documents outside the party discovery process and calls for documents and communications that are protected by Jonesworks attorney-client privilege and the work product doctrine. Any responsive Edgeworth communications with or documents regarding Jonesworks are protected from disclosure by the attorney-client privilege and work product doctrine, and this court should bar enforcement of the subpoena to the extent it calls for the production of such documents. The subpoena, attached as Exhibit A to this letter, seeks to compel Edgeworth to produce, among other things, all documents and communications concerning your relationship with Jones, all documents and communications concerning your relationship with Jonesworks, all communications between you and Jones, and all communications between you and Jonesworks. Sorry, I just wanted to pause for a second there because it seems to me like she does in fact know what a lawful subpoena looks like. Okay. I'm such a dick. All right. Exhibit A, request for productions numbers 1 through 4, is I guess what they're citing there. We'll take a look at that. On March 13th, Jonesworks served objections to these requests and to the subpoena's other requests to the extent that they called for documents with or regarding Jonesworks. Exhibit B, letter from K. Toller to B. Friedman, March 13th. Counsel for Jonesworks met and conferred with counsel for the Wayfair parties on March 20th, but were unable to resolve the matters at issue. Subsequent to that conferral, Edgeworth provided responsive documents in its possession to Jonesworks solely for the purpose of Jonesworks reviewing and assessing for privilege. Jonesworks did so, and on March 31st, having determined the privileged and protected nature of the documents, served a privilege log on the Wayfarer parties. Exhibit C, letter from Kay Toller to B. Friedman, March 31st. Okay. Counsel for Jonesworks met and conferred with counsel for the Wayfarer parties again on May 2nd. So that was like last Friday. And the Wayfarer parties stated that they had narrowed the request to only documents relevant to the present litigation, but stated that their intent to pursue the subpoena despite the privileged nature of the documents sought. Counsel for Jonesworks also met and conferred with counsel for Edgeworth on multiple occasions. Edgeworth stated that it takes no position on this matter and will respond to the subpoena in accordance with the court's resolution of this motion. Jonesworks now seeks an order from this court prohibiting the Wayfarer parties from enforcing the subpoena to the extent it seeks documents and communications with or regarding Jonesworks. First, on their face, the subpoena's requests seek documents that the Wayfarer parties in this case and the related case against Jonesworks, are required to seek from Jonesworks as part of party discovery, not from Jonesworks' third-party service provider. Second, a court must quash or modify a subpoena that requires disclosure of privileged or other protected matter if no exception or waiver applies. Right. The attorney-client privilege protects confidential communications between attorney and client made for the purpose of seeking or conveying legal advice. The privilege for communication with attorneys can extend to shield communications to others when the purpose of the communication is to assist the attorney in rendering advice to the client. The work product doctrine is intended to preserve a zone of privacy in which a lawyer can prepare and develop legal theories and strategy with an eye towards litigation, free from unnecessary intrusion by his adversaries. Okay. Ordinarily, a party may not discover documents and tangible things that are prepared in anticipation of litigation. The work product doctrine does not require the documents be prepared at the behest of counsel, but only that they be prepared because of the prospect of litigation. Here, the documents the subpoena seeks relate solely to work Edgeworth has performed in connection with Jonesworks obtaining legal advice and preparing for potential litigation. I find that a little hard to believe. Though not entirely. I mean, I guess they could kind of swing it that way. We'll have to ask Omar. Because I can kind of see how they could bend and stretch that. But obviously, I don't know the ins and outs of this kind of thing. I've never seen anything like this before. All right. Jonesworks retained Edgeworth in mid-2024 after an anonymous person or persons created false and defamatory websites and social media accounts about Jonesworks. Oh, God. And if you guys don't remember those, it was like StephanieJonesLeaks.com and StephanieJonesLies.com. And one of those was still up until recently. I guess she finally succeeded in getting it taken down. But if you go to the Wayback Machine, which preserves now deleted websites, articles, whatever, you can still see that website and what was on the page, like the front page and all that. So it's not like it really accomplished too much other than, sort of having a Streisand effect, in my opinion, because now more and more people are like, well, what do you have to hide? Or is this true? Is that why you're going after them so hard? Because obviously that shit is preserved. It's the internet. It's forever. No matter how hard you try, you can't make people forget what they now know. I couldn't just pretend I didn't call all these people a bunch of cunts and later be like, I never said that, because it's the internet. It's forever, Sorry, one second. A bogus subpoena doesn't protect her when she gave the info out before she ever got a subpoena. Yeah, I mean, this is a whole different thing, because this is obviously involving Edgeworth, so it's a subpoena to Edgeworth to get information, like between the communications between Edgeworth and Stephanie Jones before that meeting, during that meeting, after that meeting, maybe with Jennifer Abel, and like how that went down, because they said they had a security guard that was kind of forcing her hand, and she claims that she felt intimidated and like frozen, kind of. So yeah, but this whole issue with the subpoena, as far as like the John Doe Van Zandt stuff, this is a whole separate subpoena we're looking into right now. So she's asking them to block a subpoena by Wayfarer to Edgeworth Security regarding communications with Stephanie Jones. All right. Dear Judge Liman, please disregard Stephanie's whining and allow to disclose all her secrets for the welfare of humanity. Well, if you do, you can't post them on StephanieJonesLies.com because that's gone now. But if anybody from StephanieJonesLies.com is watching this, please contact me because I have some questions. All right. Let's see. Where did we get to here? Right. Okay. In anticipation of foreseeable potential litigation regarding those websites and in coordination with JonesWorks legal counsel, it sought Edgeworth's investigative and analytical services in connection with those websites and social media accounts. In the ensuing months, Edgeworth performed additional services for JonesWorks in anticipation of litigation, including the matters that ultimately led to the complaint and the related case of Jones et al. V. Abel. Based on this relationship, all responsive documents in the possession, custody, or control of Edgeworth that relate to JonesWorks or communications with JonesWorks are protected from disclosure. Right? Hold on, we're going to kind of roll past this real quick because this is case stuff that I don't totally understand. All right. The work product doctrine applies to work product by a party or its representatives, including the party's attorney, consultants, surety, intimidator, insurer, or agent. Okay. Courts have frequently extended the attorney-client privilege to communications made to investigators who have provided necessary assistance to attorneys. I'm not really sure what that has to do with the interactions regarding Jennifer Abel and Stephanie Jones in that termination meeting, though. I'm not sure, because it doesn't seem like they're really asking for that. But that's just because I skimmed over the subpoena and all that. So we'll see. We'll see. No exception to the attorney-client privilege or work product doctrine applies. Rule 26B3A2. Jesus, that's that's a lot. Okay. Only permits the discovery of work product if the party seeking it shows that it has substantial need for the materials to prepare its case and cannot, without undue hardship, obtain their substantial equivalent by other means. The Wayfair parties have not and cannot make any such showing. Substantial need does not include mere surmise or suspicion, and relevancy alone is not enough to establish substantial need. Here, the Wayfair parties have not only preferred no factual basis for any substantial need, but they also cannot begin to demonstrate that they cannot obtain any equivalent information by other means, including through party discovery, where discovery has just begun. So, I wonder, like, as much as I hate to say it, I do try to be fair. And again, I'll preface this by saying I've never, seen anything like this before, so I'm gonna have to double check with Omar and ask him about this. It does seem like they kind of have a point as to, like, why would you obtain this through a subpoena to a third party when you can ask for it in discovery directly from Stephanie Jones and JonesWorks? Not that Stephanie Jones and JonesWorks won't put up a fight and go down kicking and screaming about it. I'm wondering if they do have a point there. I don't want them to have a point because I don't like them and I'm very biased. But, I'm wondering if they do have a point there. But, hey, not a lawyer, so I'm just here speculating like everyone else. All right. Nor has JonesWorks waived any privilege by putting at issue any of its communications with Edgeworth or any of the services provided by Edgeworth. Quite the opposite, prior to sending its objections to the Wayfarer parties, JonesWorks had not communicated anything regarding its relationship with Edgeworth or any of the services Edgeworth performed for it to any parties to this case. But rather than seek discovery of documents and communications in the possession of and relating to JonesWorks directly from JonesWorks in this case, or the pending related case in which JonesWorks is a party, the Wayfarer parties are seeking to use the subpoena to obtain those documents through alternative indirect means. Yeah, so that's why I don't really understand why are they doing that? I'm not saying I'm not saying they shouldn't be able to have that information. I'm just wondering why they're doing this through a subpoena to a third party rather than through discovery directly with the related party in the case. The court should reject this effort to obtain privileged documents through a backdoor that they well know they could never obtain through party discovery. Okay, so they're saying that they couldn't obtain it through party discovery, so they're taking a roundabout way, and that's where I kind of am losing the plot there. I don't understand why they couldn't obtain that through party discovery, and I guess it has something to do with this work product doctrine that they're talking about above. But there's, more to read here regarding this. So especially there's, letters between Brian Friedman and Kristen Thaler that we're going to see. So maybe they'll explain some of that. I'm not sure. Maybe it'll just make me more confused, but either way, we're going to look at it. Okay. Because the subpoena calls for documents protected by JonesWorks privileges, the court should quash the subpoena and issue an order prohibiting its enforcement to the extent it seeks documents regarding or communications with JonesWorks. All right, here's Exhibit A. This is the subpoena they sent out to Edgeworth Security. So this was written by Mitchell Schuster, one of the Wayfair party's attorneys, pursuant to Federal Rules of Civil Procedure 45A4, plaintiffs Wayfair Studios, Justin, Jamie, blah, 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 by and through their undersigned counsel hereby provide notice that they intend to serve Edgeworth Security Services with a subpoena commanding production of documents, a true copy of which is annexed here too. Okay. And then here's a copy of the subpoena. All right. And here's what they're asking for, I think. Definitions and instructions. This is probably relating to the document production requests. So these are not really going to tell us much of anything, the definitions and all that. Let's see. Because we've seen this before when we went over the motion to compel filed by Leslie Sloan against Justin Baldoni and Wayfair. Schedule A. Okay, so this is what Wayfair is asking for. All documents and communications concerning your relationship with Jones. All documents and communications concerning your relationship with JonesWorks. And remember, they have narrowed the scope of this request since then. So this is maybe not the most recent of these documents. I'm not sure. But all communications between you and Jones, between you and JonesWorks, all documents and communications concerning Able, all documents and communications concerning RWA, concerning Nathan, concerning Tag, concerning Lively, concerning Reynolds, concerning Wayfair, concerning Baldoni, all communications between you and any person concerning the action, all communications between you and Sloan, between you and Vision, between you and Lively, and between you and Reynolds. All right. Just Ricardo, thank you for the 2. To publicly make them hide, PR move. Huh. All right, let's see. And that's just the attorney's service list and all that. Exhibit B is another letter. So this is a letter from, it looks like it's from Kristen Toller to Brian Friedman. So we'll take a look at that in just a second. Give me 1 second, guys. So somebody says, hey, GG, what's going on? Sounds like maybe Stephanie has scrubbed her texts and emails to them. It wouldn't surprise me. I mean, I don't know, maybe. I'm not saying no. I'm just saying the thing is, like, especially as with Jennifer Abel's phone, Cellbrite can pick that shit up. So even if you delete it off your phone, it doesn't make it like it's impossible for them to find anymore. These days, there's technology that can mirror devices in a way that allows them to obtain or extract information that was previously on the device that you tried to delete. So it's kind of interesting, but the texts are still out there somewhere in the cloud or on the device. Let's put it that way. It's really, really hard to scrub something clean these days. You have to be like sophisticated to know how to do that. If you're just like a regular person and you're like, oh shit, I shouldn't have sent that message, or I don't want this person to know I said this about them, and you just delete it off your phone, that's not going to cut it these days. If it comes to court, or if it comes to like some sort of offense where your text messages are being subpoenaed, like, you might be kind of fucked. Not you personally, Gigi, just, you know what I'm saying? You know what I'm saying? All right. We write on behalf of our clients, JonesWorks and Jones, regarding the subpoena recently served by Wayfair parties to Edgeworth Security Services. Okay. Pursuant to Federal Rule of Civil Procedure 45, JonesWorks objects to the subpoena for the reasons stated below. Among the subpoena's 17 requests for production, request numbers 1, 2, 3, and 4 call for document and communications between Edgeworth and JonesWorks or regarding JonesWorks. Okay. Request for production 5 calls for documents and communications concerning Jennifer Abel, a former partner of JonesWorks. JonesWorks objects to each of these requests in their entirety, as each calls exclusively for documents and communications that are protected by the attorney-client privilege and the work product doctrine. JonesWorks likewise objects to requests for productions 6 through 13 in the subpoena to the extent such requests might be interpreted as calling for the production of communications with or documents relating to JonesWorks or any of its current or former employees. Okay. Oh, hey, Sarah. What's up? Thank you, mods, for being here, by the way. JonesWorks retained Edgeworth in anticipation of litigation and to prepare for the foreseeable litigation. JonesWorks has no other relationship with Edgeworth, and Edgeworth has not performed any other services for JonesWorks. Based on this relationship, all documents in the possession, custody, or control of Edgeworth that relate to JonesWorks or communications with JonesWorks are protected from disclosure. See Federal Rules of Civil Procedure 26B4D. Jesus Christ. Again, that's a mouthful, but all right. Attorney-client privilege extends to the communications with non-attorneys when the purpose of the communication is to assist the attorney in rendering advice to the client. So I don't think that's actually what happened here, though. Based on the events that have been described by both sides, it doesn't sound like that's exactly what happened here. It does not sound like that's what the security guard was there for. So that's something that they're going to have to argue, but just on its face, as a layperson, I'm kind of like, well, that doesn't really track. So I think you're kind of stretching it a bit, but maybe I'm wrong. So, all right. Courts have frequently extended the attorney-client privilege to communications made to investigators who have provided necessary assistance to attorneys. Again, don't really think that applies here. Courts also have applied the privilege to communications among non-lawyer employees of a corporation where the purpose of the communication was to provide information to counsel or aid counsel in providing legal advice. Still, don't think that really applies here. Please confirm in writing that your clients will withdraw the subpoena to Edgeworth to the extent that it calls for documents and communications with or about JonesWorks or any of its current or former employees. Okay. And Exhibit C is going to be another letter. So this one was on the 31st. When was this one? The 13th. So this was a couple weeks later. And it's again a letter written by Kristen Toller, I think. Yeah. Okay. Give me 1 second, guys. Okay. Aline, did I say that right? I hope I said that right. Aline or Alina, I'm not sure. How would Jones be able to provide communications between Edgeworth and other parties? So the communications they're trying to protect are the ones between Edgeworth and themselves. So they're saying, like, why aren't you asking us for this, basically, instead of taking it out, like, with a third-party subpoena? And then they're saying that if they were to ask Jones directly, it would be impermissible for XYZ reason that I still don't totally understand. But the weird thing here is, like, I'm wondering why is it not permitted to subpoena the third party? Or why would it not be permitted to get these documents from the direct party? So that's just me. All right, 1 sec. Okay. Dear counsel, we write on behalf of our clients, JonesWorks and Stephanie Jones, in response to your letter of March 21st, 2025, regarding the subpoena your client served on Edgeworth Security Services, LLC, in the above captioned matter. As discussed during JonesWorks conferences with both you and counsel for Edgeworth, JonesWorks has reviewed the documents that are in Edgeworth's possession, custody, and control that may be responsive to the subpoena to the extent it calls for documents related to Blake Lively, Ryan Reynolds, Justin Baldoni, Wayfarer Studios, Jennifer Abel, Melissa Nathan, Steve Sarowitz, Leslie Sloan, or any of the other individuals, companies, or issues involved in this case. As detailed in the attached privilege log, and in accordance with Federal Rule of Civil Procedure 45E2 and Local Civil Rule 26.2, all such documents are protected from disclosure and will not be produced. Lastly, JonesWorks again objects to the subpoena as an improper means of obtaining party discovery. In addition to JonesWorks' participation as the plaintiff in the related case of Jones versus Abel, your clients have pled a third-party complaint against JonesWorks in the above-captioned case. Given the timing of the subpoena, your correspondence and the third-party complaint, JonesWorks expects that your clients knew they intended to add JonesWorks as a party at the time of issuing and pursuing the subpoena to Edgeworth seeking JonesWorks documents. This only heightens the impropriety of seeking JonesWorks privileged documents from a third party as a means of attempting to circumvent the privilege. I mean, look, again, as a layperson who's been following all this stuff closely, that seems pretty fucking rich to say that, given what they have done. But if we're singling out this specific issue, I don't know how this is going to go. We expect that this letter will resolve this matter and that your clients will address any future requests for JonesWorks documents to it through the proper channels of party discovery. Okay. So yeah, I don't know how this is going to go, but here's a privilege log of JonesWorks LLC and Stephanie Jones. We have, May 10th, 2024. I was like, May 10th is tomorrow. What the okay. May 10th, 2024. We have Stephanie Jones, Chad Brockway, Michael J. Kump, and Aaron Liskin. Description: email correspondence among client, counsel, and Edgeworth regarding requests for and reports of pre-litigation consulting and forensic services relating to defamation against Ms. Jones and JonesWorks LLC in connection with anticipated litigation. Okay. My understanding is that anticipated litigation by Stephanie Jones was supposed to be against the John Does who formed those websites she was upset about, because when she filed her state case, her lawsuit in the New York Supreme Court, or whatever you call it, she had filed a complaint against Jennifer Abel and John Does, which is actually really interesting considering the Van Zandt lawsuit and the John Does one through 10 controversy. But she had named John Does in that lawsuit, and they were related to that website, those websites. So I assume that the connection with anticipated litigation was actually supposed to be against those random people who still have not been named, and I think they were dropped, actually. I'm not positive, though. So that's kind of weird. That's a little weird. That's something I have to look into more. Let's see. This communication also, email correspondence among clients, counsel, and Edgeworth regarding requests for and reports of pre-litigation consulting and forensic services relating to defamation against Ms. Jones and JonesWorks LLC in connection with anticipated litigation. Again, this was the John Doe thing, dude. That's what it sounds like to me, at least. Same deal here. November 8th, 2024 through February 10th, 2025. I'm sorry. Why do you need to pull this up through the last just 3 months ago? That's kind of weird. No? All right. May 10th through November 28th. Again, email correspondence. In connection with anticipated and ongoing litigation. May 8th to September 17th, Stephanie Jones and Chad Brockway, text messages between Stephanie Jones and Edgeworth regarding requests for and reports of pre-litigation consulting services relating to defamation against Ms. Jones and JonesWorks LLC in connection with anticipated litigation. And the privileges here they list are all attorney, client, or work product, but they don't trust that she'll give them all the information. I don't know, man. Maybe. Give me 1 second here, guys. Okay. Zong Yang, I hope I said that right. I'm sorry. I'm probably botching the pronunciations tonight, guys. I'm sorry. Isn't that the same as asking TS third party for text with Blake Lively? In a way, yes, but in a way, no. So they're kind of saying like this security firm had something to do with the process of like preparing for impending litigation. Whereas a third party subpoena to Taylor Swift would not have anything to do with any sort of security on anyone's part or any sort of pending litigation on anyone's part. So that's a little bit different. I think that would be harder to fight. This though, I feel like a lot of the points they're using to defend this has to do wow, I cannot talk tonight. Has to do with those John Does that she initially named. So that's just weird. So I wonder if she ever actually wanted to go after the people who made those websites, or if that was just a buffer. So, Just Ricardo, thank you for the 2. How you anticipate when you don't have the text? Yo. Well, she knew about the websites. That's what I'm saying. I think she's trying to pass the security she got for the pending litigation against those websites because she was upset about the what was it, Forbes or Business Insider or something article. She got that security firm who was probably present when she was talking to somebody about those websites, and is now trying to pass that off as this is privileged information or something like that. That's what it sounds like to me. But like, again, guys, I'm not a lawyer. I've never seen anything like this before. So we'll have to ask Omar maybe tomorrow night. We'll see if he's busy. So there was obviously a lot going on there, but the weird thing is, like, I almost never see it mentioned that she was suing John Doe's in her initial lawsuit against Jennifer Abel. And why were those things connected? And why was it randomly dropped? You know? So that's, to me, is something that I want to kind of think about a little bit more. It's obviously not going to happen tonight because, well, it's past 9 p.m., so I'm not doing my best thinking right now. All right. Thanks, everybody, for hanging out. I'm going to send you over to my buddy Omar. I know he was talking to my friends Snitzel Ninja and Brad, and I think he had a couple other people there about the Taylor Swift subpoena. If you haven't seen it yet, I did put out a video on that. Let me link to it right here so you guys can see it, because I had some thoughts about your angle of this and how they kind of botched the job, in my opinion, and what actually was said to the press and all that. So I'm going to put that right here. Hang on. Here's a link to it if you want to check that out. I just put that up an hour or two ago. So go look at that. But otherwise, my friend Omar, I said hello. I'll be in the chat there. I might even join in on his stream if enough people will go over there and say hi. So send lots of bacon. Tell him Lethal sent you, and we'll see. We'll see. Maybe we'll meet up over there and we can talk more about that Taylor Swift stuff and all that. So I'll see you. Thanks, everyone. Bye.